Welcome to Constitutional Chisme,
a law baddie's guide to the legal basics. I'm your host, Stephanie.
And I'm your co-host, Harleigh.
Every week, we will drop an episode that you'll likely cover your first year in law school or some other bar course in your law school journey. Make sure to pay close attention to our podcast because we will drop Easter eggs of what case we plan to drop next week. See if you can guess which one.
This episode is sponsored by Belmonte, a skincare and lifestyle brand centered around the reminder to stay still, grounded, and present. We also want to thank Kaplan Bar Prep for partnering with us. If you or someone you know is planning to use Kaplan for bar prep, be sure to use our code PASSWITHPONZ, that's PASSWITHPONZ, to save an additional $100 off of your course. This is a great way to not only save yourself $100, but support the show and ensure that we will be able to continue to give away free bar prep for future testing cycles. You can also check out our link tree in the show notes. That's where you can find links to follow us on TikTok and Instagram. You can also access our Amazon storefront, which has our favorite law school and bar prep essentials, and join our Patreon community for even more content and to support the show. You can also find an Amazon wish list to send Stephanie a present, as she is once again begging.
Please. I really want the rug. Oh, did you give our UWorld discount?
Oh, no, I didn't. Also, we have a new sponsor. Shout out to UWorld. Cut that. Shout out to UWorld. I have to save my voice for John. We would also like to thank our newest partner, UWorld. You can use code Ponzaneli 10. That's PONZANELI 10 to get 10% off your subscription to UWorld. Again, it's a great way to save yourself some money and support the show at the same time.
Also, if any of you guys are friends with Selena Gomez, can you tell her to collab with me?
Selena, I know you're listening personally, actually.
Actually, Miss Gomez, Selena, just call me up.
Just give me a ring-a-ling.
Yeah. I really want to collab with Rare Beauty so bad. I would love to do a cover. I think that's like my dream. That's my current goal right now. Is it pass the bar? Sure. Is it be on a Rare Beauty campaign? Yes. Because I would be like, you know how obnoxious I would be?
I thought we had maxed out, but I love that there's more levels to it.
Maxed out on what? Delulu?
Delulu.
I can't just stop at the wish list. Come on.
I have picked up a new hobby. Nobody asked, but
what is it?
Cross stitching, because I'm still elderly. I also crochet, y'all. But I've also picked up cross stitching.
Can you make me something?
It's going okay.
What have you made?
I haven't made anything. I haven't finished anything yet. I just started.
Oh.
And it takes forever. It takes 1,000,000 billion years.
Longer than crocheting?
Absolutely.
Fudge.
Depending on what you're making. Like, I'm sure it would be easier to do a small cross stitch project than it would be to like crochet a dress, but it takes forever. I do have a pattern though saved that I want to make you specifically.
Aww.
Yeah,
sweet.
I have one that I'm like, yeah, that's for Steph. Anyway, let's talk about what case we're gonna do today.
What case are we doing? I don't even know.
We're doing Merrell Dow Pharmaceuticals versus Thompson.
Pharmaceuticals.
Don't get too excited. It's civil procedure.
Oh, Lordy. Who picked this?
Okay. You didn't have to sound like that. Some of us like civil procedure.
I probably need to learn this for the bar anyways, so it's probably good for me.
Okay. So, before we get into this, there's something you have to know about federal courts. Federal courts are courts of limited jurisdiction, which means there are only certain cases they can hear. Now, we've talked a little bit about personal jurisdiction.
What is that again?
Right. So, personal jurisdiction is basically, can the court hear this case against this specific person? Does the court have jurisdiction over this particular person? But a court not only has to have personal jurisdiction, it also has to have subject matter jurisdiction. And subject matter jurisdiction is basically, can the court hear cases of this type? So of this subject matter. So typically there are two that are kind of the big ones. Now, don't get me wrong, there are a few others, but there are two rather big ones. And that's diversity jurisdiction, which we're not going to get into today.
Oh, man.
And federal question jurisdiction. That's what we're going to get into today.
I am so good at finding out if there's subject matter jurisdiction when it comes to a federal question being involved.
And
On
listen,
the bar.
it's not as that seems like it not a flex. It is a flex. We're going to get into it. It's a little bit more difficult than one would presume.
I didn't think it was
it's a little bit of a flex. Well, it is, Stephanie. You should be proud of yourself. It's a flex.
It literally says, this is a federal question.
Like, hey, but just stay with me. Stay with me.
Okay.
So specifically, we're talking about Title 28, United States Code Section 1331. And that says the district courts, those are federal courts, shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. So what that essentially means is whenever you are looking at a cause of action that comes from the Constitution itself or laws that are made by the United States, or laws that are made by the United States, federal courts have jurisdiction over that specifically. So let's get into the details of this particular case. Okay, so let's get into the background of this particular case. So Thompson, the Thompson respondents, as they're called, are residents of Canada.
Okay.
And the McTavishes are from Scotland.
Ooh.
And they filed basically the exact same lawsuit against the petitioner. In this case, it's Merrell Dow Pharmaceuticals. They were a corporation that manufactured and distributed this drug called Bendectin.
What does it do?
Bendectin was a popular prescription medication that was used to treat nausea and vomiting during pregnancy. So essentially, it was a morning sickness drug.
Oh, that's scary.
And it changed ingredients a few times from when it was introduced in the 1950s. This is taking place in the 1980s. But all of the formulations were essentially an antihistamine and vitamin B6. So the complaints that were filed in Ohio.
Okay.
And both of the complaints alleged that a child was born with birth defects as a result of the mother using Bendectin while she was pregnant.
Oh, snap. Okay.
Yeah. So already this is a very, very serious case. Now, again, it was filed in state court.
I do have a quick question.
Yes.
How did she know that was the reason?
So I don't think that they necessarily did know for sure, but it did come out later and Bendectin was taken off the market.
Oh.
That it was leading to birth defects and various deformities in children. So this was a lawsuit that kind of erupted from that discovery. So it got taken off the market in the late 80s. That's when this lawsuit was filed. So there were 6 counts that the two families brought against Merrell Dow. And 5 of those 6 were all common law theories of negligence, breach of warranty, liability, fraud, things like that. All of those are state law claims. That's important. However, count 4 alleged that the drug Bendectin was misbranded and was therefore in violation of the Federal Food, Drug, and Cosmetic Act, or the FDCA, because it was not labeled to provide adequate warning that the use was potentially dangerous. Now, the FDCA, the Federal Food, Drug, and Cosmetic Act, is basically what the FDA acts under. It gives the FDA, the Food and Drug Administration, it's what gives that agency its power, is the FDCA. So
quick
they
question.
alleged that the violation, what did you say?
Oh, I had a question. So had they put a warning label, then it would have been fine kind of thing?
Well, they still would have had the particular issues as far as like negligence, breach of warranty, things like that. They wouldn't have had a cause of action under the FDCA.
Okay. Which would then keep
But
it in
they're
state court?
allegedly, we're going to get to
Okay.
it. But
Okay, sorry.
that particular violation of the FDCA was what they were saying, hey, that is a federal statute. And specifically, paragraph 26 of the complaint alleged that the violation of the FDCA in the promotion of Bendectin constitutes a rebuttable presumption of negligence. And then paragraph 27 alleged that the violation of federal statutes directly and proximately caused the injuries suffered by the two infants. So again, this case was filed originally in state court in Ohio and was removed to federal district court. So removal is something that defendants can do. And it's basically when plaintiffs, who are the master of their complaint, they file it in state court and the defendants go, no. A federal court would have jurisdiction over this. I want to go to federal court, and they remove it. So it gets taken from state court and gets plopped into federal court. They said, no, to be in federal court. And they filed a motion to remand. That's essentially a motion that says federal court is not the appropriate place for this. It needs to go back to state court. The family argued that it needed to go back to state court on the grounds that the court didn't have subject matter jurisdiction. And they basically said, count 4 of the complaint, they said, y'all don't have subject matter jurisdiction over this. This needs to go back to the state courts. And the district court said, no, you literally brought a lawsuit under the FDCA, the Federal Food, Drug, and Cosmetic Act. That's federal law. That's a cause of action arising under federal law. We have jurisdiction under Title 28, United States Code, Section 1331. They denied the motion to remand. It did, however, grant a motion to dismiss on forum non-conveniens, which basically just means this is not the proper forum for this particular case.
Like place to have it, right?
Yeah, this is not the particular place to have it. So federal court generally might be correct, but the District of Ohio might not be the best place. Maybe it needs to go to the District of, let's say, Delaware instead. That's so far across the map. But this is a corporation, so corporations are typically incorporated in Delaware, as we've discussed. So they dismissed it on those grounds, and they sent it somewhere else. The families argued that the district court had gotten it wrong, and that this did not belong in federal court. It needed to go back to state court. And so it went up to the United States Court of Appeals for the Sixth Circuit. And they agreed with the families, and they reversed. And they said the FDCA did not create or imply a private right to sue for injury, which means there is no federal subject matter jurisdiction. And specifically, they said, quote, federal question jurisdiction would thus exist only if a plaintiff's right to relief depended necessarily on a substantial question of federal law. Plaintiffs' causes of action referred to the FDCA merely as one available criterion for determining whether Merrell Dow was negligent. Because the jury could find negligence on the part of Merrell Dow without finding a violation of the FDCA, the plaintiff's causes of action did not depend necessarily upon a question of federal law. Consequently, the causes of action did not arise under federal law, and therefore were improperly removed to federal court. But as always, once you get reversed, somebody's not happy. They won in the lower court. Now they've gone up to the Court of Appeals, and Merrell Dow got told that they got it wrong and that this doesn't belong in federal court. Merrell Dow didn't like that, so it appealed to the United States Supreme Court. And it went up to the Supreme Court.
What year was this?
And the Supreme Court, this was in 1986.
Okay. Not that long ago.
No, not that long ago. So Judge Stevens, writing for the majority, took as his starting point the conclusion that Congress did not intend a private federal cause of action for violations of the FDCA. In other words, private parties can't bring a suit solely on the basis of a violation of the Act. So there's nothing within the language of the FDCA that says violations of this lead to a cause of action. There's nothing in it that says if you violate the terms laid out in the FDCA, a private individual who is then affected by your actions can haul you into court. The court basically looked at the language of the Act and looked to congressional intent and reasoned that because there was no explicit language creating a cause of action within the FDCA, Congress did not intend for it to exist as a federal law under which individuals would be able to bring suit. So specifically, the court states that the significance of the lack of a federal cause of action cannot be overstated. The ruling relied heavily on the notion of respect for congressional intent. The court interpreted the fact that Congress did not create a cause of action to be conclusive evidence that Congress did not intend for claimed violations of the FDCA as elements of a state cause of action to be substantial enough to confer federal question jurisdiction. So essentially what Judge Stevens said is that just because they were alleging that Merrell Dow did not follow rules or particular procedures that were laid out by a federal statute, that was not the same thing as bringing a federal question. So compare this with something like a Section 1983 claim. That creates a particular private cause of action that says if a government official violates your constitutional rights, you can sue them. That's not what the FDCA says. The FDCA just lays out certain guidelines that food, drug, and cosmetics have to abide by or are supposed to abide by. And it's basically a litmus test for whether or not the FDA can step in, not private individuals. So the court agreed with the Sixth Circuit and said, this is not a federal question.
So just because it was the federal government that's over this doesn't mean it counts as a federal question.
Yes, just because they cited a federal statute does not mean that federal question doctrine has been invoked. There has to be, and I don't want to overstate this. It's not that a lack of a private cause of action is always dispositive. Like there's no private cause of action, so therefore no federal question exists. The court clarifies later on down the road that the absence is just one thing to look at, but the true purpose is congressional intent. And in that case, the fact that there was no private cause of action and that most of the repercussions listed out in the FDCA had to do with independent things that would be done by the FDA, that led the court to assume congressional intent was not to create a private cause of action. A lot of the times when the court does something about congressional intent, it kind of kicks the can to Congress to go, hey, if we got that wrong, you can change the language. You can make this more clear.
Oh, so it gives them a little bit more to work with.
Yeah, it's basically like, hey, this is how we interpreted it, because that's the principle of judicial review. The court can look at what Congress has said and say, this is what we think Congress meant by that. And if Congress disagrees, they can rewrite the law and make it more clear. But they looked at congressional intent in this case and they said, nope, There is no private cause of action. So there's no federal question here. So literally, a federal court cannot hear this case. It has to go back to the Ohio State Court. Bye. That's it.
Dang. So what's the holding?
So the particular issue in this case is whether the incorporation of a federal standard in a state law private action, when Congress has intended that there not be a federal private action for violations of that federal standard, makes the action one arising under the Constitution, laws, or treaties of the United States to confer federal question jurisdiction according to Section 1331. The holding was no federal question is raised because the petitioner's claim did not arise under federal law. So essentially, the Supreme Court affirmed what the Sixth Circuit had said. And the rule that came out of this was a complaint alleging a violation of a federal statute as an element of a state cause of action. When Congress has determined that there should be no private federal cause of action for that violation, does not state a claim arising under the Constitution, laws, or treaties of the United States. So it is a little bit more difficult than just, is it a federal statute, to determine whether or not there is federal question jurisdiction. So all that to say, it's kind of a flex, Stephanie, that you get those questions right. It's a little bit convoluted sometimes.
I will say on the bar, they just tell me if it's a federal question or not.
Well, yeah, to be fair, when you're taking the bar, you're not going to have the legislative history or congressional intent to look at.
Yeah. So
if that's the test, what are you supposed to do?
Yeah.
They just say, yeah, this is a federal question. I said what I said and I meant what I said.
Yeah. And they're like, so this is a federal question. Can you still have the federal court over this case, even though it doesn't meet the $75,000 requirement? And then I'm just like, yep, because it's a federal question.
Yep, because it's a federal question. We haven't gotten to diversity yet, but the $75,000 thing will make sense when we do. But yeah, that is the case of Merrell Dow Pharmaceuticals versus Thompson. It's one of the big ones for subject matter jurisdiction, specifically federal question, obviously.
Did we read that in school?
Yeah, we read it in Civ Pro.
I don't even remember it, honestly.
I don't know if it was one of the cases. You know how sometimes our professor would just have us read like particular sections because he really wanted us to read this other case.
Yeah.
But we needed to know what the law was for that other case to make sense. I don't know if this is one that we like read in depth, but it is one that we read. It was in my outline.
Oh, well, cool. I don't remember it all, but it's also been 4 years now. Isn't that weird to say?
That is weird. And also, this is a case that I cite a lot.
Really?
As a clerk. Yeah, Merrell Dow is like one of the first things that you quote whenever, because you have to do a jurisdictional review on most things. When it's it's one of the first motions in a particular case, or if someone's making a motion saying that there's a lack of subject matter jurisdiction.
Mm-hmm.
So Merrell Dow gets quoted quite frequently.
I see her every day
in my writing. I see her every day. Okay, well, that's all I have for today's case.
Well, thank you so much. I do want to go ahead and thank our sponsors, Belmonte. We love her skincare. Make sure you click the link in our show notes. It's also in our Instagram bio, and it's in my personal TikTok bio because I don't have enough followers to put it in my podcast TikTok.
Yeah, so go follow the podcast TikTok, guys.
Yeah, come on.
Stop playing. You're hurting my feelings.
Yes, and leave a review. If it's a bad one, don't leave it because that's just
never
rude,
mind.
But like,
if you like it, leave a review. Thanks.
And if you don't like it, you can just send me a gift from my Amazon wish list and send in the note what you didn't like about it. That comes with my gift.
If you're gonna give me bad news, break it to me gently.
Yes. Also, if you know Selena Gomez, please let her know to reach out to me to collab. That's my really big dream right now. I'm not going to stop until I get the collab. Um, and I'm going to name off a couple discount codes for you guys. So if you are going to use Kaplan Bar Prep, or you know anyone who's going to use Kaplan Bar Prep, use our code PASS with PONZ. It's all caps, PASSWITHPONZ. And then we also have a discount code with UWorld, which is my last name, Ponzaneli, PONZANELI 10. Ponzaneli 10. Use that to save an extra 10%. If you're going to shop with Belmonte, use code STUDYMUSE15 and you'll get 15% off your entire order. So use our discount codes. Check out my Amazon wish list. Check out our Amazon storefront. We suggest what you should buy for law school or just the bar exam or just in general, right? Cute stuff for you. And as always, make sure you follow us on all our social media platforms.
Period. We'll see you next time. Bye.
Bye.